Hey, what's up, guys? It's Jamie. Just real quick, we're going to cut to the issues here with this whole, George Zimmerman shooting down, that 17-year-old black male here in Sanford, Florida, and the stand your ground rule and how that, interplays here because it's being demonized, and I think that there needs to be some clarification. First and foremost, if you haven't heard about it, there's a guy, he was a neighborhood watch guy, he was, looking around his neighborhood, saw this kid named Trayvon Martin, and he decided to take things into his own hands. He called police. They said don't go after him. He goes after him. Facts and kind of money there. But he ends up shooting the kid in some sort of scuffle. Okay, so a lot of people are complaining, saying, oh, this stand your ground law in Florida, 776.013, just for your reference, section 3 specifically, is enabling these type of people to go and be vigilantes. Well, the fact of the matter is we got a big problem here because the case law already goes against what he did. Specifically, if you are going after somebody who's fleeing, there's actually a case law on that, and that I will provide you with name in just a second, stemming back from 2007, that says that if somebody's fleeing, you're no longer standing your ground defensively. And that is, say the specific case, the State v. Heckman case, that's 993 SO period 2D 1004 from 2007, that's the 2nd District. If somebody is retreating, you can't be standing your ground. In other words, you have the right to stand your ground if somebody's coming at you. But if that person is retreating, you have no right to go after him, which is why, in this case, Zimmerman is clearly outside the protections of immunity. And what does the immunity do normally? The immunity means that if you are to be charged with a crime, your attorney can file a motion to say that you're presenting this defense, a stand your ground defense, and then the judge has to approve finding facts, preponderance of the evidence that you did or didn't, meet that standard burden of proof to get the immunity. In this case, Mr. Zimmerman, especially on case law, clearly does not fall within the protections. Even the authors of the bill say he does not fall within the protections. Why in this case is very obvious. You can hear from the phone call. He was chasing after a guy. The guy was fleeing. He was standing his ground, but he continued to move toward the other guy, so he's no longer standing his ground. So, with that in mind, it's really important to see that the focus here should be on the police, prosecution. Why? Because they're the ones who make the decision whether or not to arrest somebody and whether to charge somebody. Okay, so that means the police here and the prosecutors, it's up to them to be vigilant. It's up to them to go and get the facts, get a grand jury indictment, all that jazz. Once they do that, Mr. Zimmerman can definitely be brought to justice. So this law, on the surface, you might be saying to yourself, oh, but man, that's just going to empower people. Well, no, it really doesn't, because you can still get in trouble for committing, obviously in this case, some sort of negligent or reckless manslaughter. And yes, of course, if there are less witnesses around, someone might try to claim in a scuffle that the other person was the aggressor. Certainly they could try to abuse in that way. But again, just like any other criminal case where there's a lack of evidence or witnesses, you have the same issues. In other words, somebody gets murdered, and there isn't exactly all the pieces together to find who did it, or the evidence is decayed, think Caliente or something like that. You don't necessarily get justice right off the bat. And so a lot of people are complaining like, oh, why isn't, Mr. Zimmerman brought to justice? Why isn't he arrested? Well, you know what? You need to be asking the prosecution and the police officers. This isn't about the law. Stand your ground is a great principle. And for the most part, it's going to provide what it does, which is a defense for everybody who needs to defend themselves in the moment, to not flee. If a mugger or rapist is coming after you, the last thing anybody wants to do is to think, oh, do I have to turn my back? Or, oh, do I have to take 3 steps back? Because then you're leaving yourself up vulnerable. And that's just wrong. That's wrong to force innocent people to be left vulnerable. Of course, there's going to be criminals trying to exploit the law, but that's not the point. The point of the law is to protect people who are following it, who are defending themselves. And of course, you could still get charged, and you could still get brought before a judge, and you still have to prove, with preponderance of the evidence, that you are qualified to stand your ground. And that's specifically saying that you have this reasonable belief that someone is about to cause you great bodily harm, death, or is about to commit a forcible felony. Okay, it's serious stuff, and it's something that needs to be looked at from the context of the law and what the police and the prosecutors are doing. Stop letting the politicization of this break down a great law. This is about the police not acting. This is about the prosecution not acting, and maybe they're afraid that the case is weak on the evidence, but that's their fault. You know what I mean? That's why there needs to be people looking at police, looking at prosecution to do their job. So just a real quick summary of that. I hope that helps. And of course, do your own research, especially in the case law, think critically about this. Look at the core principles. Don't take away the rights of people to defend themselves when really this is just a clear example of somebody violating this protection. It's clear that they were chasing after somebody that were not standing their ground. All right, take care, and I'll talk to you soon.